Section 28, as it's commonly known, is something that has been evolved in the courts at the moment. It's been trialled and so on, and it's coming across more courts in England and Wales, whereby the complainant is giving his or her evidence much earlier in the trial. A complainant will, in the first instance, when they're at the police station making their complaint, do something that's called an ABE, Achieving Best Evidence. It's a video. The police are videoing that evidence, and that evidence, subject to certain editing, will be the main evidence in chief of that complainant when the matter gets to the Crown Court. Up until Section 28, that person would then be cross-examined by our barristers. I'm going to use the word live in court, but that person could choose to be live in the courtroom, but more often than not chooses what's called a special measure, and they give evidence from in the courtroom but in a different building over a video link or from behind a screen in the witness box, whatever suits that person best. And there's absolutely no issues with that. That's common, and the judges give directions to the juries in relation to say that that's common. However, with Section 28, Section 28 is counted as though it's day one of the trial, but yet the cross-examination may take place only a matter of weeks after the defendant's first appearance in the Crown Court. I have difficulties with Section 28. The prosecution don't always comply with what they should do. When one is in the Crown Court, the first hearing that one faces is called a PTPH, a pre-trial preparation hearing, where the judge of that court sets a timetable with dates in it. Prosecution do this, defence do that, and so on. And the first thing is called stage one, and the prosecution are supposed to prepare all their papers, that what they have to do by a certain date. Then the defence file a defence statement by another date, and then the Section 28 takes place. Now, imagine this. Two scenarios. One, the prosecution haven't served all their material by their date. So we don't have to file the defence statement until we get it, but they haven't sent it. So we haven't filed the defence statement. But then the Section 28 day is looming. What do you do then? Do you hope the prosecution are going to serve it, or are you going to go in front of the judge and say, well, we can't file the defence statement because we haven't got all the papers from the prosecution? The judge may not be sympathetic to you. The judge may say, well, you've got enough, Mr. Sutton. Your guy can get on with it. Come on, get on with it. We're going to have the Section 28. I don't think that's acceptable. A different situation. Let's say you're charged with offences against person A. You're starting that process, whether or not you've received all the documentation by way of disclosure from the Crown. The Crown and prosecution are words that mean the same thing, Crown Prosecution Service. You may or may not have got your documentation. Then person B complains. So that process has started again. Your guy is back in the police station, he's answering different questions, but that case is then further back down the road. Case 1 started off, case 2 is following on. Case 1 and case 2 are usually subject to what's called joinder. The two cases have been brought together more often than not. Then you've got to get to a situation where you're asking the court to adjourn the initial set of stages, have a new set of stages for part 2, put all those stages together, and then have your Section 28. Now the difficulty you have is, what if these two complainants know each other? What if your client is saying that this is an issue of contamination? This is an issue of these two women having gotten together because they don't like you for whatever reason it may be. So you've had your Section 28 cross-examination of one of them. Let's say one of them's under 18, and therefore that first one has had her Section 28, so she knows what questions are coming. But the other one isn't. She's maybe 25, let's say, over 18 anyway. And so the 18-year-old, the 17-year-old, who has had her cross-examination, if collusion and contamination is part of the defence, could go and tell the other woman, oh, well, they've asked me this and they've asked me that. So the next woman has a heads up. How can that be fair? This has to be about fairness. There's been a government edict recently in relation to many criminal offences, but sexual offences particularly, in that the government seemed to want to have more convictions. More convictions is not, in my opinion, the answer. The safeguards for the complainants are there already. We have Section 41 in relation to previous sexual history. We have this new Section 28, which is supposed to be a safeguard. We have the ABE evidence in the first place. All the safeguards are there. The police and the prosecution need to use them properly. And in my respectful opinion, Section 28 is emasculating the defendant.